All right, welcome back, everyone. Today, we're going deep into a world that can feel like a whole other language, legalese.
You know, it's fascinating, isn't it, how so much power is packed into those legal agreements.
Exactly. And I know our listeners want to decode contracts and, well, feel more confident dealing with all the legal stuff, whether it's for upcoming deals or just to be more informed, savvy.
Absolutely. Everyone should have a grasp on this stuff.
So we've got a great mix of sources today, actual contract language, explanations, and even some real-world problem scenarios.
Yeah, it's a really diverse collection.
And our mission really is to help you grasp the key ideas, the core principles, without getting lost in all the jargon.
Distilling it down to the essentials.
Exactly. So let's start, I guess, at the bedrock, contracts of sale.
The foundation, you could say. A
Yeah.
contract of sale is, at its core, a legally binding promise.
A promise, okay.
Where one party, the seller, agrees to transfer ownership of something specific, and the other party, the buyer, agrees to pay a predetermined price for it.
Okay, simple enough on the surface. But our sources highlight three must-haves for it to be legit, for it to be binding. Consent, object, and price.
Yeah, those are the cornerstones. Let's break those down a bit. Consent means that both the seller and the buyer are willingly agreeing to the terms. It's really like a meeting of the minds.
Okay.
No coercion, no trickery involved.
And both sides have to be legally capable of making that deal, right?
Right.
Like a kid can't sell a house, for instance.
Precisely. Now, the object is the actual thing being sold.
Right.
It has to be clear what it is. This is where that example from our problem scenarios about selling a car from the garage gets a little tricky.
Yeah, that one had me scratching my head a little bit. Why wouldn't that fly?
Because it's vague. If the seller has multiple cars in their garage, which one is being sold, that lack of clarity could make the entire contract unenforceable.
So you're saying specificity is key.
Absolutely. You need to know exactly what's changing hands. Now, price also needs to be certain, a clearly stated amount that both sides agree on.
Okay, so no wiggle room there. Our sources also mention absolute and conditional sales.
Right.
What's the difference between those two?
So an absolute sale is straightforward. Ownership transfers as soon as the deal is done.
Okay.
Think buying groceries. You pay, you get the goods, you're the owner right then and there.
I see. Okay, so what makes a sale conditional then?
A conditional sale means there's something that has to happen first before ownership fully transfers. Usually it's the full payment of the price.
Ah, okay, so like buying a house with a mortgage.
Exactly.
You don't fully own it until you've paid off that loan.
That's a perfect example. The seller technically still owns it until that condition, the full payment, is met, even though the buyer might be living there, using it.
Okay, that makes sense. Speaking of real estate, our sources bring up the statute of frauds. What's that all about?
The statute of frauds. It's a rule that says certain contracts, especially those involving real estate, have to be in writing to be enforceable. No handshake deals for land.
Got it. So to avoid any he said, she said drama, get it in writing.
Precisely. A written contract protects both sides by, clearly laying out all the details. Now, let's shift gears to the seller's side of things. Their responsibilities, they go beyond just handing over the item.
All right, so what are those obligations? Give us the lowdown.
Well, their primary duty is to deliver the object of the sale. Sounds simple, right? But there are different types of delivery, including constructive delivery.
Okay, constructive delivery.
Yeah.
What does that actually look like in practice?
Imagine buying, say, a huge antique armoire. Instead of physically moving it, the seller gives you the keys to the warehouse where it's stored. That's constructive delivery. Transferring control, access.
Interesting. So it's not always about physically handing something over.
Right. There are legal nuances to these different types of delivery, each with specific implications. Now, beyond delivery, the seller also provides something called a warranty against eviction.
Warranty against eviction.
Yeah.
Okay, that sounds pretty serious.
It is. It means the seller is guaranteeing that the buyer won't be, kicked off the property because someone else has a legal claim to it. It protects the buyer's peaceful possession.
So nobody wants to buy a house only to find out they have to move out because, someone else actually owns it.
Exactly. It's all about ensuring a clear title and peaceful possession for that buyer.
Okay, so we have delivery, warranty against eviction. Anything else sellers need to watch out for?
Yes, hidden defects. Sellers are responsible for disclosing any flaws that significantly affect the item's value or usability.
Okay.
Think about our example, the one with the used washing machine with the cracked drum that the seller knew about but didn't mention.
Ah, yeah, yeah. Not cool. What can a buyer do in that situation?
They can demand a remedy, like returning the item for a full refund or getting a price reduction to account for the defect.
Okay, so honesty really is the best policy here.
Absolutely. Being upfront avoids headaches for both sides. And one final point for sellers. Res paret domino.
Res paret domino. Now that's a mouthful. What's that all about?
It's a legal principle. Essentially, it means the thing perishes with its owner. It addresses what happens if the item is lost or damaged before it's delivered.
Okay.
Generally, the risk stays with the seller until ownership is fully transferred.
Okay. Lots to consider there for sure. Now, before we move on to the buyer side, I have a question about something from our problem scenarios.
Right, shoot.
What if someone sells something for like a ridiculously low price?
Yeah.
And then, they have seller's remorse, they regret it. Can they back out of the deal just because they think they got a bad deal?
That's a great question, and it touches on this idea of gross inadequacy of price. While it might seem unfair, a low price alone doesn't usually void a contract.
So even if it's like a steal, a total
Sure.
bargain, the deal might still be valid.
Yeah, unless there's proof of fraud, pressure, or something else that interfered with the seller's consent.
I see.
A low price by itself isn't enough to break the deal.
Interesting. So it's crucial to, think carefully about that price before you sign anything. Now, let's flip the script. Talk about the buyer's role in all of this. What are their obligations and rights?
So while their main duty is paying the agreed upon price, they also have certain rights and protections.
Okay.
It's a two-way street, as it should be.
Right, right. So what are some of those buyer's rights? Give us some examples.
Well, they can refuse delivery if there's a valid reason. Say you ordered a custom-made couch and it shows up the wrong color.
Oh, yeah.
You have the right to refuse it because it doesn't match what you agreed to.
So it's not just about taking whatever the seller gives you.
Exactly. Buyers have a right to make sure they get what they bargained for. And even if it's not explicitly spelled out in the contract, there are what are called implied warranties that protect them.
Implied warranties, what are those?
Well, one of the big ones is the warranty of merchantability. This basically means the item is fit for its usual purpose. A toaster should toast bread, not just look pretty.
Right, it should function. Makes
Yeah.
sense. But what happens if the buyer can't hold up their end of the bargain? Like, say they start missing payments.
That's where specific laws come into play. For movable property, there's the recto law. And for real estate, we have the Masada law.
Okay.
They provide a framework, a set of rules for dealing with those situations, and they outline both the rights and the remedies for both sides.
All right, well, we've laid the groundwork. We've covered those basic contract elements, the responsibilities for both sellers and buyers, and even touched on some of the legal frameworks that come into play.
It's a lot to take in.
It is. I'm ready to dive a bit deeper into those laws, though, especially when it comes to installment sales, because, those are so common.
Yeah, that's where things get really interesting because so many of us engage in installment sales regularly.
Exactly. So shall we explore the specifics of those laws?
Let's do it.
All right, I'm all ears.
All right, so let's dig into the recto law. It specifically deals with installment sales of movable property, those things you can physically move.
Okay, so we're talking like cars, appliances, furniture, that kind of stuff.
Exactly. Anytime you're buying those kinds of things on an installment plan, the recto law is there to protect both the buyer and the seller.
Okay, so what does this law actually say? What are the key things we need to know?
Well, a big part of it focuses on what the seller can do if the buyer misses payments, what remedies they have.
Okay, so what are their options in that scenario?
They've got a few choices. First is specific performance, meaning they can legally force the buyer to make those remaining payments.
So it's not just about taking back the item. They can actually make the buyer pay up.
That's right. It's all about, enforcing that original agreement. Their second option is to cancel the sale. That means taking back the item if the buyer isn't, paying as promised.
So in that case, the buyer loses the item and any money they've already paid.
Yeah, that can happen. But the recto law, has rules about how the seller has to go about it. They can't just barge in and, grab the stuff. They have to follow procedures. They have to give the buyer proper notice.
So there's some protection built in for the buyer there too.
Absolutely. And their third option is foreclosure.
Foreclosure. Isn't that usually something you hear about with houses?
Yeah, it's often associated with real estate, but it can apply to movable property under the recto law too.
Okay.
It basically means the seller can, essentially sell the item to get back the money they're owed.
So say someone buys like a fancy new TV on an installment plan,
Hmm.
and then they can't make the payments. The seller could repossess that TV and then like resell it to cover their losses.
Exactly. The RECTO law provides that framework. But remember, we talked about fairness for buyers earlier, right? The RECTO law has that covered too.
Okay, so what kind of protection does it offer to buyers?
One key thing is grace periods. If a buyer misses a payment, they get a certain amount of time to catch up before, facing those more serious penalties or having the item repossessed.
Right, because, everyone hits a rough patch sometimes.
Exactly. And another important right is the cash surrender value. If the buyer has already made a bunch of payments and then they just can't continue for whatever reason, they might be able to return the item and get some of their money back.
Okay, so it's like a safety net in case things go wrong.
Yeah, that's a good way to put it. Now, moving on to real estate purchases, we have the Masada law. It's kind of like the RECTO law's counterpart, but
Yeah.
specifically for, land, houses, condos, that kind of thing.
Okay, so the Masada law is all about protecting those who are buying real estate on those installment plans. What are some of the key things it does?
Well, just like the RECTO law, the Masada law provides for those grace periods. If you miss a payment, you don't automatically lose the property. You have a window to get caught up.
Okay, so even if I miss like a mortgage payment, I don't immediately lose my house. That's a relief.
Exactly. And the length of the grace period depends on how many years worth of payments you've already made. Basically, 1 month of grace for every year you've paid.
Okay, so if I've been, diligently paying my mortgage for 5 years and then hit a financial snag, I would have 5 months to get back on track.
Exactly. It incentivizes those consistent payments. Let's look at an example from our materials. Someone's buying a residential lot and they've been paying for, say, 18 months, a year and a half. Then they miss a payment.
So they're not quite at that 2-year mark yet.
Correct. But they still get a grace period. The seller has to give them at least 60 days from that missed payment to try and fix things.
So there's a minimum level of protection there, even if they haven't been for all that long. What happens if they still can't make the payment after that grace period?
Then the seller can start the cancellation process. But it's not as simple as just saying you're out. The Masada law has strict rules about how they have to go about it.
Strict.
Yeah.
Okay. What do they have to do?
First, they have to send a formal, notarized notice of cancellation to the buyer. And that notice doesn't immediately end things. The buyer still has 30 days from when they receive that notice to try and rectify the situation.
So even after getting that notice, they've got a whole month to catch up and save the deal.
That's right. It's an extra layer of protection. And there's a court case, Valenzuela v. Court of Appeals, that really underscores how important those steps are. In that case, the seller tried to cancel the contract without following those rules, and the court sided with the buyer.
So sellers can't just cut corners and expect to get away with it.
Nope, the law is there to protect buyers from being taken advantage of. Now, remember that cash surrender value we discussed with the RECTO law? Well, it applies under the Masada law, too.
So if I've paid at least 2 years' worth of installments on a property, and then something happens, I can't continue, I might be able to, back out and get some of my money back.
You got it. It's calculated based on how much you've already paid. It starts at 50% of the total, and then it increases for each year you've paid beyond the first 5. But it can't go over 90% of the total you've paid in, even if you've been making payments for a really long time.
Interesting. So there's a balance there, protecting both the buyer and the seller's interests. What are the consequences, though, if a seller tries to cancel a contract without following the Masada law properly?
Well, failing to follow those rules, it can backfire big time. That cancellation, it could be deemed invalid, meaning that contract would still be in effect and the buyer could stay put.
Wow, so they could keep living there and making payments.
Exactly. Their rights wouldn't be affected. Plus, the seller could even be sued for damages. Think legal fees, moving expenses, that kind of thing.
So there are real consequences for trying to game the system.
Absolutely. The Masada law has teeth. It's there to ensure fairness, a fair process. Okay, we've spent quite a bit of time on those installment sales laws, but we've really only just begun our journey, ready to explore other types of contracts.
Absolutely. What's next on our legal adventure?
Let's move away from buying and selling and look at a different way to legally use someone else's property, lease agreements.
Ah, leases. Those things we all find without reading when renting an apartment.
Well, hopefully you give them a good look. They lay out the terms for that temporary use of property.
Okay, so what makes a lease agreement valid? What are the essentials there?
There are two key ingredients. First, you have the temporary use of the property. The tenant gets the right to use the property for a certain period, but they don't own it.
Right, it's not like buying it outright. It's more like borrowing it for a while.
Exactly. And then the second crucial part is the payment of rent. The tenant agrees to make those regular payments to the landlord in exchange for using the property.
Okay, so temporary use, rent payments, those are the basics. Now let's talk about responsibilities. What are the landlords and the tenant, obligated to do under a lease agreement?
The landlord, well, they have a duty to provide the property in a condition that's suitable for its intended use. So if it's an apartment, it should be habitable, you know, working plumbing, electricity, those basic amenities.
Makes sense. You're paying to live there. It should actually be livable. What happens if a landlord doesn't make those necessary repairs, like when a roof starts leaking?
Generally, repairs are the landlord's responsibility, unless the damage was, the tenant's fault. If the roof is leaking, they need to fix it.
Our problem scenarios mention this. What if the landlord just ignores those urgent repairs? Can the tenant just withhold rent?
That's a tricky one, and the law gives tenants some options there. First, they should always put the repair request in writing to, create a record of that communication. If the landlord still doesn't act, the tenant might be able to, reduce their rent until the repairs are done, or in some cases even break the lease entirely because the landlord isn't holding up their end of the bargain.
So tenants do have some leverage if things aren't right. Now, what about the tenant's responsibilities? What are they supposed to do?
Their primary obligation is, paying that rent on time in the way specified in the lease. That's the core of the agreement. They also have a duty to use the property responsibly and avoid causing damage.
So no wild parties that trash the place.
Right. They should treat the property with care, just like it was their own. And if they do cause damage beyond, normal wear and tear, they're usually responsible for fixing it.
Okay, so leases are about, setting those clear expectations for both sides, making sure everyone knows their role and what they're agreeing to. Now, what about this agency thing mentioned in the materials? What exactly is an agency agreement?
It's when one person, the agent, is authorized to act on behalf of another person, the principal.
So it's like having someone handle your business for you.
Exactly. The agent can, represent the principal in dealings with other people. Think of real estate agents. They act on behalf of homeowners to sell or lease properties, or power of attorney where, someone might be authorized to manage your finances or make healthcare decisions if you can't do it yourself.
So it's all about delegating authority to someone you trust. What makes an agency agreement legit, though? What needs to be in place?
Well, both the principal and the agent need to agree to it. That's consent. Then the agreement needs to spell out what the agent is actually authorized to do. That's the object of the agency. It might be managing all of the principal's affairs or just selling a specific item. It varies.
So the agent can't just go rogue and do whatever they want.
Exactly. And lastly, the agent has to be acting for the principal's benefit, not for their own personal gain. They're like an extension of the principal in a way.
Okay, got it. Now, the materials mention different types of agents.
Right.
Universal, general, and special. What's the difference between those?
So a universal agent has the broadest authority. It's like giving someone complete control over your affairs. They can pretty much do anything you could legally do yourself.
That sounds like a lot of trust. When would someone use a universal agent?
It's not that common, to be honest. You might see it if someone's unable to manage their own affairs due to, illness or incapacity.
Okay, what about a general agent? What can they do?
A general agent's authority is more limited, but still broad. They can handle, all matters related to a specific business or activity. Think of like a general manager of a company.
So their power is confined to a certain area, not everything the principal does.
Right. And then there's the special agent. They have the narrowest authority. They're appointed for a very specific task or transaction, like selling a particular property or negotiating a specific contract.
Okay, so we've got the different levels of agent authority there. But what about responsibility? What are the agent and the principal obligated to do in this relationship?
So the agent has some key duties. First and foremost, they have to be loyal to the principal. That means acting in their best interest and avoiding any conflicts of interest.
So no shady side deals where the agent benefits at the principal's expense.
Exactly. They also have to be obedient, meaning they have to, follow the principal's instructions. And they need to be diligent and skillful, performing their tasks competently and with reasonable care.
So basically they have to be like, trustworthy and good at their job. What about the principal? What are they obligated to do?
They have to compensate the agent for their services, whether it's a fee, a commission, or some other arrangement. And they need to reimburse the agent for any reasonable expenses they incur, while doing their work.
So if the agent travels for business, the principal needs to cover those costs.
Right. And the principal also has to protect the agent from any losses or liabilities they might face, as long as the agent was acting within their authority.
Okay, so both sides have their roles, their duties. How do you actually end an agency agreement, though?
There are a few ways it can happen. The principal can usually revoke the agent's authority unless it was granted for a specific period or tied to a particular interest. The agent can also choose to renounce the agency, basically quitting. And of course, if either party dies or becomes incapacitated, the agency ends automatically.
Makes sense. Anything else that would terminate it?
Yeah, if the job is done, the agency ends. If an agent was hired to sell a specific item and they succeed, their role is complete and the agency is over.
Okay, that's pretty straightforward. All right, we've tackled leases and agency agreements. Where to next?
Let's delve into the world of credit transactions, loans, deposits, and all those fascinating ways we borrow and lend money.
Okay, let's talk about credit. I'm ready to learn about the legalese behind loans and mortgages.
Great. Let's start with the foundation of borrowing loans.
Yeah.
Our sources highlight two main types, commodatum and mutuum.
Commodatum and mutuum, are we casting spells now? Those sound like something out of Harry Potter.
Ah, they do have a magical ring to them,
Right.
but in reality, they're just legal terms for different types of loans. Commodatum is a loan of something non-consumable.
Non-consumable. What does that mean in plain English?
Think of borrowing a book from a friend. You use it for a while, but you return the same book. You don't consume it in the process.
So it's about borrowing something that stays intact.
Exactly. And commodatum loans are generally gratuitous, meaning, they're free, no interest payments or fees, unless you specifically agree to it.
So no interest on that borrowed book.
Right. Now, mutuum is a bit different. It's a loan of something consumable, usually money. You don't return the exact same thing that you borrowed.
So if I borrow $100, I don't have to give back those same bills.
Correct. You repay the equivalent amount, even if it's different bills or comes from a different bank account.
That's more like the loans we're used to. You borrow money and pay it back, often with interest.
Exactly. And unlike commodatum, mutuum usually involves those interest payments. The lender is compensated for the use of their money.
Makes sense. Now, here's a curveball. The sources say sometimes even consumable things can be the object of a commodatum loan. How does that work?
That's a good observation. It's not common, but it can happen. Imagine an artist borrows a basket of fruit from their neighbor, not to eat, but as a model for a still life painting. They'd return that same fruit later.
But it's consumable, like in theory, but not in the context of that specific agreement.
Precisely. It all depends on the intended use. Now, let's move beyond loans to another type of credit transaction, deposits. These involve entrusting someone with your property for safekeeping.
Like putting your money in the bank.
Exactly. That's a classic example. But there are other kinds of deposits too. Our sources distinguish between judicial deposits and extrajudicial deposits.
Okay, what's the difference there? They both sound pretty serious.
A judicial deposit happens when a court orders property to be held by a neutral third party during a legal battle. Say there's a dispute over who owns, I don't know, a valuable painting. The court might order it to be deposited with someone impartial until the case is settled.
So it's a way to protect that item while things get sorted out in court.
Exactly. Now, extrajudicial deposits, they're more common. These happen by agreement between the parties, no court order needed.
Could give me some examples of those extrajudicial deposits.
Think of asking your neighbor to hold your spare key while you're on vacation. That's a simple, a gratuitous deposit. No money is changing hands there. Just trust.
Right. What about a deposit that does involve payment?
Think of storing your stuff in a storage unit. You're paying that company to keep your belongings, safe and sound.
So extrajudicial deposits can be free or paid depending on the setup. Are there any other categories within those?
Yes, there are voluntary deposits, which are made by choice, and necessary deposits, which are made out of, well, necessity.
Okay, I'm following so far. Give me an example of a necessary deposit.
Imagine you're caught in a storm, and have to take shelter. You might need to leave some of your belongings with a store owner or hotel clerk for safekeeping.
Right. It's not like you plan to leave your stuff there.
Yeah.
The situation forced you to.
Exactly. Our sources specifically mention deposits made by travelers in hotels. Those are considered necessary deposits, and the law says hotels they have to take reasonable steps to protect those belongings.
So if my luggage gets stolen from my hotel room, the hotel could be in trouble.
It depends. Hotels have to provide reasonable security, and if they don't, and something happens to a guest's stuff, they could be liable.
Okay, so knowing the ins and outs of deposits is crucial.
Okay.
Especially when you're traveling.
Absolutely. Yeah. Now let's switch gears and talk about something a bit heavier. Guarantee and suretyship.
Guarantee and suretyship. Those sound like big league legal concepts. What are we talking about here?
Essentially, these are agreements where someone agrees to back up someone else's debt. Think of it like being a cosigner on a loan.
Okay.
You have the primary debtor, the person who owes the money, and then you have the guarantor or surety who agrees to step in if the primary debtor can't pay.
Okay, so what's the difference between a guarantor and a surety? They both sound like they're on the hook if the main borrower defaults.
That's the key distinction. A guarantor's liability is secondary. They only have to pay if the primary debtor, fails to pay, and the creditor has tried everything else to recover that debt.
So the lender can't go after the guarantor first. They have to go after the main borrower's assets and all that before coming to the guarantor.
Exactly. The guarantor is like a backup plan. Yeah. Now, a surety is different. They primary liability, meaning they are equally responsible for that debt from the very beginning.
So if the borrower, disappears, the lender can go straight to the surety and demand full payment.
That's right. There's no need to exhaust other options first. Now, remember we talked about the benefit of excusation earlier? That's a key protection for guarantor.
Right. It's like a shield that prevents the lender from coming after the guarantor, prematurely.
Exactly.
Yeah.
The lender has to exhaust all those legal options against the primary debtor before turning to the guarantor. They might try to garnish wages, seize assets, or take other legal action.
So it's not just a matter of sending some strongly worded emails. Mm-hmm. They have to actually go through legal hoops to get that money from the primary borrower.
That's right. But there are exceptions to this protection.
Like what? When wouldn't a guarantor have that benefit of exception?
Well, if they specifically waive it in writing, then they're giving up that protection. And if the guarantor signs on as solidarily liable, then they're basically treated like a surety, meaning equal responsibility from the start.
Okay, so the specific language of the agreement, it really matters.
Absolutely. Now, another important thing to note is that even though a guarantor isn't primarily liable, they might still get pulled into any legal action if the lender decides to sue the main borrower.
Wait, so even if they're not the main target, they might still have to go to court.
It's possible. The lender might want to include the guarantor in the lawsuit to make sure they're bound by whatever the court decides.
Okay, so even being the backup can get messy.
Yeah, it's something to be aware of. But on the flip side, if if the lender and the borrower, they work out a deal, maybe accepting a lower payment or changing the terms, that agreement also applies to the guarantor.
So the guarantor benefits from any deal the lender makes with the borrower.
Exactly. They can't be forced to pay more than what the borrower ultimately agrees to.
Okay, so there are some perks to being a guarantor. Now, what happens if you have multiple guarantors, like a group of friends backing up their buddy's loan?
Good question. In those cases, the liability is usually split equally among them unless their agreement states otherwise.
So they're sharing that risk.
Exactly. And each one individually gets the benefit of extension. The lender has to try to collect from the borrower and from each guarantor separately before recovering that full amount.
Okay, that makes sense. Now, I know we touched on mortgages earlier when talking about the Mesita law, but I think it's time we delve deeper into those.
You're right. Mortgages are a whole world unto themselves, ready to explore.
Bring it on. Let's decode the legalese of mortgages.
All right, let's break down those mortgages. At its core, it's a loan that uses real estate as collateral. The borrower is pledging their property to the lender as a guarantee.
So if the borrower doesn't repay the loan, the lender can just take the property, kind of like a pawn shop, but for houses.
That's the gist of it. The mortgage gives the lender that legal claim to the property if things go south.
Okay, so what makes a mortgage agreement, legally sound? What boxes need to be checked?
First off, it has to be in writing. No handshake deals when you're talking about real estate and big loans.
Got it. What about the people involved? Any rules about who can be a borrower, who can be a lender?
Well, the borrower, the one putting up their property, they have to actually own it. They can't, mortgage something that isn't theirs.
Makes sense. Any limits on what kind of property can be mortgaged?
Generally, any real estate is fair game. A house, a condo, land, even commercial buildings. But there might be some local rules or zoning issues that could limit things.
Okay, so the property has to be, eligible for a mortgage. What else is needed?
For the mortgage to be enforceable against others, it needs to be registered with the government, usually at the Registry of Deeds.
So it's like putting a big sign on the property that says, "Hey, there's a mortgage on this."
Exactly. It puts everyone on notice that there's a lender with a claim on that property.
Now, you mentioned if the borrower doesn't pay, the lender can take action.
Mm-hmm.
How does that actually play out in real life?
That's where foreclosure comes in. It's the legal process where the lender can, take possession of the property and sell it to get back the money they're owed.
It's the lender's last resort, you could say.
You could say that, yeah.
All right. Walk me through this foreclosure process. What are the steps involved?
There are two main ways it can happen. Judicial foreclosure and extrajudicial foreclosure.
Two types. Okay, what's the difference?
Judicial foreclosure is the more formal route. The lender goes to court, they file a lawsuit, and if they win, the property is optioned off to the highest bidder.
So it involves judges, lawyers, court dates, the whole 9 yards.
Exactly. Extrajudicial foreclosure is a bit faster. It bypasses that court system and uses a special power of attorney that was granted to the lender in the mortgage contract itself.
Wait, so the borrower is basically giving the lender permission to sell the property if they default right there in the mortgage agreement?
That's the idea. It streamlines the process, makes it more efficient.
Okay, but that sounds kind of risky for the borrower. What protects them in that situation?
Well, even with extrajudicial foreclosure, the lender still has to follow rules. They have to give the borrower proper notice. And importantly, both types of foreclosure, they involve something called the right of redemption.
Redemption. Didn't we talk about that before?
You're right. We did, but it comes up again here. The right of redemption gives the borrower a chance to get their property back even after it's been foreclosed on.
Hold on. So even if the lender has already taken the property, the borrower can still reclaim it?
Yes, but they have to act fast. They need to repay that full debt, plus any extra costs within a specific time frame.
Okay, how much time do they have?
It depends. Mm-hmm. With judicial foreclosure, it's usually a year from the date of the sale. Extrajudicial foreclosure has a shorter time frame, often just a month.
Okay, so it's a second chance, but they're on the clock.
Exactly. Redemption is a crucial safety net for borrowers.
This is all incredibly useful information. I mean, we've covered, loans, deposits, guarantee, suretyship, mortgages, foreclosure. It's a lot to take in, but I'm starting to see how all these pieces fit together.
It's like a giant puzzle,
Yeah.
and we're putting the pieces together one by one. And speaking of puzzles, there's one more concept we need to revisit. Redemption.
Redemption again. We just talked about that with mortgages.
Yes, but redemption is broader than just foreclosure. It
Oh,
it
yeah.
applies to other situations where someone might want to buy back property they've sold.
Okay, remind me, how does that work exactly?
So there are two types: conventional redemption and legal redemption.
Okay, and what's the difference between the two?
Conventional redemption is something that the seller writes into the original sale agreement. They reserve the right to buy back the property within a specific time frame. Usually it involves paying back that purchase price plus some extra expenses.
So it's like a built-in undo button for the seller, if they have second thoughts.
Exactly. Now, legal redemption is different. It's a right granted by law to certain people, even if it wasn't part of that original sale contract.
Interesting. Who gets this legal right of redemption?
Co-owners of a property and adjoining landowners, they're common examples.
Okay, so how does that play out with co-owners?
Imagine you and your siblings, you inherit a piece of land. If one sibling decides to sell their share to someone outside the family, the other siblings have the right to buy that share back, keeping it within the family.
So it's a way to prevent outsiders from coming in and kind of messing with the existing ownership structure.
Precisely. Now, with adjoining landowners, it's about protecting their interests regarding those neighboring properties. Imagine you own a farm and your neighbor decides to sell their land. You might have the right to buy it even if you weren't involved in that original sale.
Why would I want to do
And
that?
maybe you want to expand your farm or prevent someone you don't like from becoming your neighbor, or make sure the way they use the land is compatible with your own farming practices.
So it's about like control and influence over what happens next door.
Exactly. Legal redemption gives those adjoining landowners a voice.
Wow, we've covered so much ground today. I mean, contracts of sale, leases, agency agreements, all sorts of credit transactions, and now even the ins and outs of redemption. My head is spinning with all this legal knowledge.
It's been a whirlwind tour through the world of legalese, but remember, we've just scratched the surface.
There's always more to learn, right?
Absolutely. The law is a constantly evolving field. New situations, new interpretations, they pop up all the time.
So how can our listeners continue their legal education? What are some good next steps for them?
Well, the sources we use today, they're a fantastic foundation. From there, it's all about, feeding your curiosity. Read legal textbooks, explore online resources, or even talk to a lawyer if you need, specific guidance.
Great advice. Now, before we wrap up this deep dive, I want to leave our listeners with something to think about.
I like where this is going. What do you have in mind?
We've spent a lot of time talking about the letter of the law, the technicalities, but let's not forget that human element. Even if something's legally okay, it doesn't always mean it's the right thing to do.
You're absolutely right. Ethics matter a lot.
So as you navigate your own agreements, I encourage you to think not just about what's legal, but also what's fair, what aligns with your values, and how you're treating that other party.
Couldn't agree more. Integrity is key in any relationship, especially when contracts are involved.
Well said. A huge thank you to our expert for sharing their incredible legal knowledge and making this deep dive, so insightful.
It was my pleasure.
And to our listeners, thank you for joining us on this legal adventure. We hope you feel more confident about decoding legalese and making informed decisions in your own lives.
Remember, knowledge is power, and understanding the law, it can help you protect yourself and achieve your goals.
Until next time, stay curious, keep learning, and we'll see you on our next deep dive.